Imagine living in a world where the rules meant to protect society accidentally become a criminal's best friend, where a single typo can free a murderer, and being too drunk to remember your crime might be your golden ticket to freedom. This isn't some dystopian novel. We've uncovered 50 real laws, legal loopholes, and courtroom tactics that seem almost purpose-built to let the guilty walk free. Welcome to a journey through the looking glass of justice, where what's legal and what's right don't always shake hands. 1. Let's start with something that sounds like a bad joke but is terrifyingly real. In some jurisdictions, if you're drunk enough when you commit a crime, you might have a legitimate defense. It's called voluntary intoxication, and while it rarely works for violent crimes, it can absolutely help with crimes that require specific intent. The logic goes like this. If you were so blackout drunk that you couldn't form the mental state required for the crime, then technically you didn't commit that particular crime. So the law is essentially saying that pre-gaming hard enough might downgrade your charges. Brilliant legal strategy or an invitation to chaos. 2. Here's a favorite among white-collar criminals. It's called willful blindness, and it's exactly what it sounds like. If you suspect your business partner is doing something illegal, but you deliberately avoid finding out the details, you can sometimes claim you didn't knowingly participate in the crime. It's the legal equivalent of covering your eyes and saying, "I don't see anything wrong here." Corporate executives have turned this into an art form, creating elaborate systems where they're insulated from the dirty details. They get the profits, but maintain plausible deniability. The law calls it a gray area, everyone else calls it exactly what it is. 3. In the United Kingdom, if you're extremely drunk and someone takes advantage of that to get you to commit a crime, you might have what's called a defense of intoxication by deception. Imagine someone getting you blackout drunk specifically so you'll help them rob a store. If you can prove you were manipulated through intoxication, the law might let you off the hook. It's a fascinating protection that also happens to be a criminal masterclass in how to recruit accomplices with complete immunity for them. 4. Let's talk about something called the rule of lenity. When a criminal law is ambiguous and could be interpreted multiple ways, courts are supposed to interpret it in the way that's most favorable to the defendant. This means if lawmakers write a sloppy law, the criminal gets the benefit of the doubt. It's a principle designed to prevent government overreach, but it also means that legislative incompetence directly translates into get out of jail free cards. The worse the writing, the better your chances. 5. There's a beautiful loophole in tax law where criminals can sometimes avoid additional penalties by honestly reporting their illegal income. Yes, you read that right. Drug dealers, thieves, and fraudsters can file their taxes and declare their criminal earnings, and the IRS can't share that information with law enforcement in most cases. The famous mobster Al Capone got caught because he didn't pay taxes on his illegal earnings. Modern criminals learned the lesson. They rob you and then file the paperwork like responsible citizens. 6. In several U.S. states, there's a fascinating window of time called the abandonment defense. If you start committing a crime but then change your mind and stop before completing it, you might not be guilty of an attempt. For example, if you break into a house with the intent to steal but then feel guilty and leave without taking anything, you could argue you abandon the criminal enterprise. It's a legal doctrine that rewards criminals for having second thoughts, even if those thoughts come a little late. 7. The marital communications privilege is a gift that keeps on giving for criminal couples. Not only can your spouse refuse to testify against you, but any private conversation you had with them during your marriage is protected from disclosure. You could literally plan a heist in bed, and your spouse can never be forced to reveal what you discussed. It's the ultimate safe space for criminal conspiracy, blessed by the law and wrapped in the sanctity of marriage. 8. Here's where things get wild. In some places, if police lose or destroy evidence, even accidentally, it can result in your case being dismissed entirely. There's a legal doctrine called spoliation of evidence, and it doesn't require the destruction to be intentional. If a crucial piece of evidence gets lost in a flood, damaged in storage, or accidentally recorded over, a defense attorney can argue that their client's ability to defend themselves has been compromised. The criminal walks because someone's basement flooded. 9. Let's Let's discuss selective prosecution. This is when a defendant argues they're being unfairly targeted, while others who committed the same crime aren't being prosecuted. If you can prove the government is going after you specifically for discriminatory reasons while ignoring similar offenders, you might get your case dismissed. It's a high bar to clear, but it's been done. The defense essentially argues, yes, I did it, but so did everyone else. And you're only prosecuting me because you don't like me. And sometimes that actually works. 10. The concept of legal impossibility is a mind-bender. If you attempt to commit a crime, but what you're trying to do isn't actually illegal, you can't be guilty of attempt. Classic example, you try to illegally hunt a deer out of season, but it turns out it's actually opening day and perfectly legal. You had criminal intent. You took criminal actions, but you can't be convicted because you accidentally stayed within the law. You're rewarded for being wrong about being a criminal. 11. There's a statute called the Speedy Trial Act that requires federal prosecutors to bring a case to trial within 70 days of indictment. But here's the catch. Those 70 days don't include any time taken up by defense motions, continuances, or procedural delays. A skilled defense attorney can file motion after motion, each one pausing that clock, stretching those 70 days into years. If the prosecution ever slips up and the clock expires, the case can be dismissed with prejudice, meaning it can never be refiled. 12. Time becomes the criminal's international law. Ally. There's something extraordinary called diplomatic immunity, but it goes even further than most people realize. Not just ambassadors, but their entire families and staff can be immune from prosecution. A diplomat's adult child could theoretically commit serious crimes, and the host country can't arrest them, can't search their residence, and can't prosecute them. The only remedy is to ask them to leave. It's the ultimate privilege, and it's been abused more times than anyone wants to count. 13. Let's talk about the good faith exception to the exclusionary rule. Even if police execute a search warrant that's later found to be invalid, if they honestly believed it was valid at the time, the evidence they found can still be used. It's a loophole to a loophole. The original rule said illegally obtained evidence is inadmissible. This exception says, but not if the cops made an honest mistake. It protects police from their own errors while doing nothing for the defendant whose rights were violated. 14. Civil forfeiture is the reverse. Robin Hood of legal doctrines. Police can seize your property, including cash, cars, and homes, if they suspect it was involved in a crime. Notice the word suspect, not prove. The burden then shifts to you to prove your property is innocent. Yes, your money has to prove it's not guilty. Even if you're never charged with a crime, getting your property back requires a lengthy legal battle that often costs more than the seized assets are worth. It's a system that punishes people who haven't been convicted of anything. 15. There's a common law defense called defense of property that can shield someone from assault charges. If you use reasonable force to protect your property from being stolen or damaged, you generally can't be prosecuted for assault. The absurd part is the definition of reasonable varies wildly by jurisdiction. In some places, you can use deadly force to protect property. In others, you can barely touch someone. A criminal can study local laws and know exactly how much violence they can reasonably use to protect their stolen goods from being stolen back. 16. Parallel construction is a law enforcement technique that's essentially legal evidence laundering. If police learn about criminal activity through questionable means, like warrantless surveillance, they can work backwards to find a legal way to discover the same information. They then present only the clean investigation to the court, hiding how they actually first learned about the crime. It's technically legal, but creates a system where defendants can't challenge the real origin of evidence against them because they never know what it is. 17. The criminal statute of limitations creates a bizarre reality where patience equals immunity. For many crimes, if you can simply avoid getting caught for a specific number of years, you can never be prosecuted. Different crimes have different clocks. Wire fraud, 5 years. Tax evasion, 6 years. You could orchestrate a massive financial fraud, live quietly for the required time period, and then literally publish a book about how you did it. The law won't touch you. Time heals all wounds, including the criminal's fear of prosecution. 18. let's discuss something called creative sentencing. Some judges have the authority to impose unusual sentences that seem more like performance art than punishment. Community service? Sure, but we're talking about sentences like write an apology letter to everyone in town, or stand on a corner holding a sign confessing what you did. While humiliating, these alternative sentences often let criminals avoid jail time entirely for serious offenses. It's punishment that prioritizes creativity over consistency, and the criminal who gets an artistic judge in contract law, there's a principle that illegal contracts are unenforceable, which sounds good until you realize it protects both parties. If two criminals make an agreement to split stolen goods and one backs out, neither can sue the other without admitting to the underlying crime. This creates a protective bubble around criminal enterprises, where neither party can seek legal remedy, but it also means they both escape legal consequences. The law's refusal to get involved becomes a shield for everyone involved in the illegal activity. 20. The concept of transferred intent works in both directions, and one direction heavily favors criminals. If you intend to punch person A, but accidentally hit person B, you're still guilty of assault because your intent transfers. But if you intend to commit crime A and accidentally commit crime B instead, you might not be guilty of crime B if it requires a different, specific intent. You could plan to steal a car, accidentally commit vandalism instead, and potentially argue you're not guilty of vandalism because you didn't specifically intend to vandalize anything. Your criminal intent gets lost in translation. 21. The juvenile justice system is built on the worthy principle of rehabilitation over punishment, but it creates an absurd protection for young criminals. Depending on the jurisdiction, a person can commit serious crimes as a minor, have their records sealed when they turn 18, and enter adulthood with a completely clean slate. They can apply for jobs, housing, and even licenses for positions of trust, and legally answer no when asked if they've been convicted of a crime. A violent history disappears, like it never happened. 22. Let's talk about the alibi defense and its bizarre cousin, the I was committing a different crime alibi. If you're accused of robbery at location A, but you can prove you were actually burglarizing location B at that time, you have an alibi for the robbery. Defense attorneys have successfully used this strategy, effectively saying, my client couldn't have committed this crime because he was too busy committing that crime, and if the statute of limitations has passed on the alibi crime, or if prosecutors can't prove it beyond the defendant's admission, the criminal walks free from both. 23. There's a protection buried in many employment laws that shields criminals who are good at their jobs. If someone commits fraud or embezzlement but the company doesn't discover it for years, during which time the person became essential to operations, prosecutors sometimes offer sweetheart deals to avoid disrupting the business. The criminal's value to the company becomes leverage in plea negotiations. They steal from their employer, become indispensable, and then use that position to negotiate minimal consequences. It's hostage negotiation with your own career. 24. The doctrine of qualified immunity protects government officials from civil liability unless they violated clearly established constitutional rights. This creates a catch-22 where if the specific violation is novel enough, there's no clearly established precedent, and the official is immune. This has been used to shield law enforcement and other officials from consequences even in egregious cases. While not directly protecting traditional criminals, it creates a class of people who can violate rights with impunity, which is perhaps the most absurd criminal protection of all. 25. In some jurisdictions, there's a defense called cultural defense, where a defendant can argue their actions should be judged in the context of their cultural background. While this can serve justice in some cases, it's also been controversially used to seek leniency for crimes by arguing they're culturally normalized in the defendant's homeland. It creates a two-tiered system where identical acts might be judged differently based on who commits them, and a savvy criminal can potentially weaponize their heritage. 26. The lawyer-client privilege is sacrosanct, but it extends to some surprising places. If you tell your lawyer where you buried the murder weapon, they can't tell anyone. If you admit to to crimes you're not charged with, that's protected. If you plan to commit perjury, they should advise against it, but the conversation is still privileged. A criminal has a licensed professional who must keep their secrets, even when those secrets involve ongoing harm. It's a constitutional necessity that also happens to be a criminal's perfect confidant. 27. Let's discuss the concept of fruit of the poisonous tree, but with a twist. There's an exception called inevitable discovery. Even if evidence was obtained illegally, if prosecutors can prove they would have found it eventually through legal means, it can still be admitted. This creates a bizarre, hypothetical game where courts decide what might have happened in an alternate timeline. The criminal's freedom depends on a judge's speculation about theoretical police work that never actually occurred. 28. In many states, you can't be convicted based solely on the testimony of an accomplice without corroborating evidence. This means if your partner in crime rats you out, but there's no other evidence, you walk free. It's a protection against false accusations, but it also means that smart criminals can commit crimes with only one witness, their equally guilty partner, knowing that testimony alone can't convict them. The more isolated and secretive the crime, the harder it is to prove. 29. The concept of jury nullification is the nuclear option in any criminal case. A jury can simply refuse to convict, even when guilt is obvious and proven, if they believe the law itself is unjust or the punishment is too harsh. They don't have to explain themselves, and their decision is final. It's democracy in its rawest form, and it means 12 random people can override the entire legal system based on nothing more than collective conscience or whim. While it's been used for noble purposes, it's also freed clearly guilty defendants because the jury simply didn't feel like convicting. 30. The right to a jury of your peers sounds fair until you realize it means convincing just one person out of 12. In jurisdictions requiring unanimous verdicts, a single stubborn juror can cause a mistrial. If prosecutors decide not to retry the case, the criminal walks free. It's the ultimate numerical loophole. One sympathetic person out of 12 is all you need. Defense attorneys have turned jury selection into psychological warfare, looking for that one person who can be persuaded. Let's talk about criminal appeals and the absurdity of harmless error doctrine. Even if the trial court made mistakes, the conviction stands if appeals judges believe the errors were harmless and didn't affect the outcome. Sounds reasonable, except it works in reverse too. If there were errors that benefited the defendant, prosecutors generally can't appeal an acquittal due to double jeopardy. So judicial errors that help criminals are permanent, while errors that hurt them might be dismissed as harmless. The scales tip in interesting directions. 32. In many places, police need reasonable suspicion to stop you and probable cause to arrest you, but the definitions are maddeningly vague. What looks suspicious in one neighborhood might be completely normal in another. What one officer considers probable cause, another might not. This inconsistency creates pockets of immunity where criminals can operate, knowing that in certain areas or situations, police legal standards are so unclear that any arrest might be challengeable. The vagueness that's supposed to protect citizens also shields criminals who know how to exploit it. 33. The concept of time served can create absurd outcomes. If you're arrested and can't make bail, you might sit in jail for months or even years waiting for trial. If you're eventually convicted, you get credit for that time. But if the trial is delayed long enough, you might have already served more time than your eventual sentence. Prosecutors sometimes offer deals where the sentence is time served, meaning the criminal pleads guilty, gets a conviction on their record, but walks out immediately. The punishment was entirely pre-conviction, turning the presumption of innocence on its head. 34. Let's discuss the insanity defense's lesser-known cousin, diminished capacity. While full insanity means you didn't know right from wrong, diminished capacity argues you had reduced mental function that prevented you from forming specific intent. It doesn't get you off completely, but it can reduce first-degree murder to manslaughter. The criminal admits they did it, but argues their brain wasn't working at full capacity. It's a dimmer switch on criminal responsibility. 35. In white-collar crime, there's a beautiful dance called cooperation agreements. If you commit fraud with others and you're the first to cooperate with investigators, you can often get complete immunity in exchange for testimony against your partners. This creates a race to the prosecutor's office. Multiple criminals can commit the same crime, but the one with the fastest lawyer and loosest lips walks free while everyone else goes to prison. Loyalty is punished. Betrayal is rewarded. 36. The right to confront your accuser sounds fundamental, but it gets weird with confidential informants. Police can arrest you based on tips from informants whose identities are protected. You can be convicted based partially on information you can't challenge because you don't know its source. While there are supposed to be safeguards, it creates a system where anonymous accusations carry weight, and the criminal who happens to be accused by an unreliable informant might never know. They're fighting tainted intelligence. 37. Let's talk about the absurdity of parallel state and federal jurisdiction. You can be acquitted in state court and then tried for the same conduct in federal court under different charges. It's technically not double jeopardy because they're separate sovereigns, but tell that to the defendant who thought they were done. Conversely, a criminal can sometimes choose which system to be prosecuted in by the nature of how they commit their crime. Jurisdiction shopping for the most favorable laws and sentences. 38. The concept of stand your ground laws in some states removes the duty to retreat before using deadly force. While designed for self-defense, it's been used in cases where someone provoked a confrontation, then claimed they felt threatened and stood their ground. The criminal can engineer a situation where they're legally allowed to use violence by claiming subjective fear, even if an objective observer would see them as the aggressor. Fear, real or performed, becomes a legal shield. 39. In bankruptcy law, there are exemptions that protect certain assets from creditors even when you owe massive debts. A person can defraud investors of millions, get sued, declare bankruptcy, and still keep their homestead, retirement accounts, and other protected assets. They destroy lives financially and retire comfortably on money that's legally shielded from the people they wronged. The law protects the criminal's future, while their victims get pennies on the dollar. 40. Let's discuss civil rights lawsuits and the bizarre doctrine of municipal immunity. If a police officer violates your rights, you might sue them personally, but good luck collecting from someone on a public salary. If you sue the city, they might be immune unless you can prove the violation resulted from official policy, not just a rogue officer. The criminal in uniform might face no real financial consequences, and the government entity that employed them is protected by layers of immunity. The victim is left with a moral victory. Federal sentencing guidelines were supposed to create consistency, but instead created another game to exploit. They calculate sentences based on point systems involving criminal history, role in the offense, and acceptance of responsibility. Defense attorneys have become experts at manipulating these points. Admitting guilt at the right time, downplaying your role, and strategic cooperation can shave years off a sentence. Two people who committed the same crime can get wildly different sentences, based entirely on how well they played the points game. 42. There's a strange protection in the American with Disabilities Act that extends to recovering addicts and people with mental health conditions. While this is generally good policy, it's been used in criminal cases to argue for leniency or alternative sentencing. A person's drug addiction, which may have fueled their crime spree, becomes a protected disability that courts must accommodate. The criminal's illness becomes both explanation and shield, and punishment gets balanced against accommodation requirements. 43. Let's talk about the right to a public trial and its evil twin, the right to suppress publicity. Defendants can argue that pretrial publicity has tainted the jury pool and get their case moved to a different venue where they might get more sympathetic jurors. In extreme cases, they can get charges dismissed if they can prove it's impossible to get a fair trial anywhere. The more notorious and well-covered the crime, the stronger this defense becomes. Infamy becomes immunity. 44. In many jurisdictions, there's a concept called deferred adjudication, or pretrial diversion. If you're a first-time offender or charged with certain crimes, you can have the case postponed while you complete requirements like community service or counseling. If you successfully complete the program, the charges are dismissed. You committed the crime. Everyone knows you committed the crime, but legally it's as if it never happened. It's a second chance that completely erases the first mistake. 45. The concept of castle doctrine allows you to defend your home with force, but in some states, it extends to your vehicle and workplace. The legal definition of castle keeps expanding. There are cases where people claimed castle doctrine in their RVs, in their temporary hotel rooms, even in cars they were just sitting in. The more liberally a state interprets your castle, the more situations exist where a criminal can claim they were just defending their territory, even if they engineered the confrontation. 46. Let's discuss the wild world of three strikes laws and their unintended protection for smart criminals. These laws mandate harsh sentences for third felony convictions, but they only count convictions, not arrests or charges. A savvy criminal can commit multiple crimes, but plea bargain each one down to a misdemeanor, never getting that first strike. Meanwhile, someone who goes to trial and loses might get struck one for a lesser offense. The system punishes those who exercise their right to trial while rewarding those who deal. 47. In evidentiary rules, there's something called prior bad acts, evidence that's generally not allowed. If you're on trial for robbery, prosecutors usually can't tell the jury about the 5 other times you were arrested for robbery, unless it's directly relevant to the current case. The jury is supposed to judge you only on what you're charged with now, not your pattern of behavior. The repeat offender looks like a first-timer to the jury. The criminal's history becomes legally invisible. 48. The right to effective assistance of counsel sounds great, until you try to prove your lawyer was ineffective. You have to show not just that your attorney made mistakes, but that those mistakes changed the outcome of your case. It's an incredibly high bar. Your lawyer could sleep through testimony, fail to call crucial witnesses, or miss filing deadlines. But if the appeals court thinks you would have been convicted anyway, you're stuck with the results. It's a protection that has more holes than shield. 49. Finally, before we get to our number 1, let's talk about the ultimate criminal protection hiding in plain sight, the requirement for proof beyond a reasonable doubt. This is the highest burden of proof in the American legal system, and it should be. But a reasonable doubt isn't defined numerically. It's not 90% sure or 95% sure. It's a feeling. One juror's reasonable doubt is another's moral certainty. A skilled defense attorney doesn't need to prove innocence. Just create a vibe of uncertainty. They just need to make you doubt, and doubt is the most subjective thing in the world. Before we reveal our final shocking law, it's time for our verdict. Looking back at these 49 legal absurdities, which one do you think offers the most outrageous protection to criminals? Is it the affluent escaping consequences through bankruptcy shields? The informant system that lets anonymous accusations carry weight? Or maybe it's jury nullification, where 12 people can simply ignore the law entirely? Drop your pick in the comments below, because we're about to reveal the most absurd criminal protection of all. And it might surprise you. 50. The single most powerful shield protecting criminals isn't a loophole or a technicality. It's the very foundation of our entire system, the presumption of innocence. Every single person accused of a crime is presumed innocent until proven guilty. This means the government carries the entire burden of proof, while the defendant can literally sit in silence and do nothing. They don't have to prove where they were, explain suspicious behavior, or justify anything. The state must overcome that presumption, and if they fail by even the smallest margin, the defendant walks free. This sacred principle, the bedrock of free society and fair justice, is also mathematically guaranteed to protect guilty people. It must, by design, because protecting one innocent person is worth letting 10 guilty ones go free. Or is it 100? 1,000? Where's the line? So there you have it. 50 laws, loopholes, and legal realities that seem designed to help criminals escape justice. We've spent this entire video highlighting what appears broken, absurd, and frustrating about our legal system. But here's our final question for you, and it's the most important one. Look back through this list and find just one law that, despite seeming to protect criminals, is actually absolutely absolutely necessary for a free and fair society? Which one would you defend? Which absurdity is actually wisdom in disguise? Scan through the list again, pick the one you'd fight to keep, and tell us why in the comments. If you enjoyed this deep dive into the complicated world where justice and absurdity collide, hit that like button and subscribe for more content that makes you question everything you thought you knew.